And we decided collectively that it was probably not a good idea to have Nick on this panel, because Nick was general counsel at the USPTO at the time Arthrex was working its way through the patent office. So it would probably be pretty limited as to what Nick could actually say about the case safely, being recused from commenting on the case since he actually worked on the case. But I thought maybe it would be interesting if Nick just gave a few words of introduction on his impressions about the PTAB before we got going. So Nick is going to introduce the topic for us, and then we'll have a conversation.
Great, thanks, Gene. So in 2007, Professor John Duffy, then at George Washington University, wrote an article in which he asked simply, is the PTAB unconstitutional, or are the APJs unconstitutionally appointed? That prompted litigation that required Congress to ultimately fix the statute, because it turns out they were. Then in 2011, Congress passed a different statute that created a new problem with the PTAB. And in 2019, we got the Federal Circuit decision telling us that, once again, there was a problem and they were unconstitutionally appointed, or at least that they had more authority than they could for the method of appointment that Congress chose. So then we spent a number of months litigating that question, and as Gene said, I helped litigate it up to the Supreme Court. But the PTAB has generated, I think, more constitutional questions and more Supreme Court litigation than any other administrative body in the history of our republic. And I look forward to hearing what the panel has to say about what the future is. So we have Scott McEwen, a partner at Ropes Gray and the head of their PTAB practice, and Sharon Israel, a partner at Shook Hardy, and of course, Gene Quinn, who needs no introduction to this distinguished audience.
Thanks, Nick. And before we get going, and I turn it over to our moderator, Scott, this is a CLE panel, so if anybody needs CLE, we have a sign-in sheet, and we also have, so we'll pass the sign-in sheet around, and we have some surveys that go along with the CLE and everything. So it's approved for CLE in Texas, and for 1 hour, and Texas has reciprocity with California and New York, we know for sure. So, and it probably has reciprocity with other states as well. So take it away, Scott.
Thanks, Gene. And as a PTAB practitioner and listening to the past two panels, I'm just glad my life insurance has been paid up. A little rough. It's getting a little rough in here. But to Matt's point, and I think what we've seen in terms of litigation, did I call him Matt again? It's Nick, right? I've done that twice now. But, you know, in terms of the litigation we've seen at the PTAB, I think it's a little bit more about, I think, this idea of patent exceptionalism that we've had for a while now, and we've seen it over the years where Zerko seemed to come kind of late in the games. Well, we have to follow the Administrative Procedures Act, and we have to use a certain standard of evidence, and we've seen that sort of play out at the PTAB as well, on all these APA issues. And then on top of that, I think you've got PTAB, which has been very controversial in its own right. I think we've all been through Quozo and oil states, and when we, at least I thought, well, oil states, that's got to be the last of the constitutional challenges, right? You know, right to a jury trial was litigated up to the Supreme Court, and we had the PTAB sort of blessed in terms of its existence. And so we've seen this repeated challenge to the system on various, what seem like, you know, small issues, but, you know, the impetus behind the challenge is always, well, let's tear down the system for a lot of the reasons we heard earlier, you know, that it's changed the game, and it's made monetization, you know, certainly more difficult, and there's a lot of reasons for that, and we can get into that. But you know, just starting with the concept of this panel and getting through what happened in Arthrex and what the debate was, and again, I think it gets back to, well, wait a minute, we have to, you know, the political appointee is supposed to really have the last word of the agency. Every other agency works that way. You know, the PTO is always doing things off in the corner, whether it's, you know, a little bit quirky on some of its rule practices or whatnot. So again, this bubbles up to the Supreme Court, and we get the feedback on, well, did you guys realize that there's this appointments clause issue? So with that, maybe Sharon, you could get into a little bit of the specifics of what the Arthrex dispute was really about.
Sure. Thanks, Scott. Although I think Nick covered it at a high level, I'll get into just a few more details. Or let me ask the audience. I mean, how familiar are you with the background of Arthrex? Would it be helpful to go through a little more of the specifics of what actually happened there? Okay, I'm not seeing any hands one way or the other. Yes. Okay. We'll go through it. So. Well, the Supreme Court decision came out in June, but it helps to go back with a little bit of perspective. So I'll give you some personal perspective. I was listening to, and I like to listen to Federal Circuit arguments, and I was driving from Houston to, I think, Austin or San Antonio for a meeting, and I was listening to a Federal Circuit argument, and it was at the beginning of October of 2019, and it was a really long argument, and I heard Judge Moore, who's now the Chief Judge, was on the panel, and it was Melissa Patterson from the Department of Justice who was representing the USPTO in the case, and I could tell this was going to be a big deal. And that was argued at the beginning of October, and October 31st of 2019 is when the Federal Circuit issued its panel decision. And the timing was a little bit interesting too, because maybe at some point in the middle of October, the panel had asked for some additional briefing, and when the government's involved, they always need a little more time. That decision had to have been ready to go, because usually precedential decisions get circulated at the Federal Circuit for usually 10-day review, and this came out very quickly. So it was the Halloween decision that came out kind of late in the day, and the decision basically said that the appointment of the administrative patent judges violated the Appointments Clause of Article 2 of the Constitution, and the remedy was that they decided was somewhat narrowly tailored, but it basically, the way they fixed it was so the APJs were not going to be covered by the removal protections under Title V. So, in other words, administrative patent judges, based on the solution here, could be terminated at will. My personal view, that created a lot of problems, because now you've got administrative patent judges who, we want to have good judges. We want to have people who know, who can get appointed, who will want to, not only can we recruit good ones, we want them to stay. And we don't want them to be concerned that the wrath of, that they come up with the wrong decision in one case and they risk being fired for any reason, or no reason. So this started trickling then through the system, and I'll back up a little bit further. So when the AIA was enacted 10 years ago, actually 10 years ago this month, one of the provisions is Section 6 of Title 35 that addressed the composition of the PTAB panels, and it says it's the composition of the PTAB, and it said it includes the director, the deputy director, the commissioner for patents, the commissioner for trademarks, and the judges of the Patent Trial and Appeal Board. That's your composition. So of those, only one of those people is appointed with the advice and consent of the Senate. It's presidentially appointed with the advice and consent of the Senate, and that's the director. And the rest of them, the APJs, it said would be appointed by the Secretary of Commerce, in consultation with the director. Then you've got Section 6C of Title 35 that says that all these proceedings are going to be heard by at least 3-member panels, and only the Patent Trial and Appeal Board may grant rehearings. That's the last sentence of Section 6C. So, okay, the Appointments Clause, what does it say? Well, the appointment clause says that the president nominates and by and with the advice and consent of the Senate shall appoint officers, meaning the principal officers. And then it says Congress, though, may by law vest the appointment of inferior officers in others, which includes the heads of the department, or here it would be the head of the Secretary of Commerce, the head of the Department of Commerce. So the way things had been working was the Secretary of Commerce would appoint the APJs. And now we've got 200 plus administrative patent judges who are comprising the PTAB, and we've got this challenge in the Arthrex case as to whether they are constitutionally appointed. So in Arthrex, Arthrex was the patent owner, and they appealed a decision that canceled their claim. So we've got the losing patent owner appealing a PTAB decision to the Federal Circuit. And the Federal Circuit came down with its Halloween decision 2019, and then we see this percolating through the Federal Circuit for some time. So we see some other issues and decisions that come out of that, including there were decisions where the Federal Circuit applied similar rationale in, I think, in a Vernetics case that said that the same constitutional problem also seems to apply to from appeal from inter partes reexamination. That the constitutional problem also applied from appeals from ex parte appeals. So we're not necessarily just talking about trial proceedings, although the Supreme Court decision that we will talk about in a second does focus its focus on the appeals in inter partes, or the procedures for inter partes review proceedings. And there was also a case actually that challenged the appointment, or at least peripherally challenged the appointment based on of the judges, the administrative trademark judges that comprised of the TTAB. There was a case actually in the decision that came down within the last couple weeks that seemed to have said, the TTAB is a little different. So it sounds like that's not much of an issue. But basically, what happened is the Federal Circuit said that the judges were acting because their decisions were not reviewable by the director, the constitutionally appointed, the person who came through the executive branch, that they were wielding too much authority, and therefore their appointment was a violation of Article 2. Everybody requested rehearing en banc. The USPT, the director did, the Arthrex did, Smith and Nephew did. Nobody was happy with the Federal Circuit's decision. And the Federal Circuit decided they declined to take the case en banc and just waited for it to percolate through the Supreme Court. In the meantime, the USPTO issued an order. There's an order in May 2020 that applied to all cases that were being remanded back to the Federal Circuit, and they held every remanded case in abeyance. So now we're stacking up hundreds of cases that are now being remanded, or it's well over 100 cases that were remanded to the Federal Circuit that were supposed to be heard before a new panel. That are sitting back there where nothing's happening with those cases. And finally, we get a decision, we get an appeal to the Supreme Court, they grant cert, and the Supreme Court says that the unreviewable authority wielded by APJs during an inter partes review is incompatible with their appointment by the Secretary to an inferior office. And the remedy that they provided was that the director may review the PTAB decisions, and upon review may issue decisions himself on behalf of the board. So the Supreme Court decision was split. There's 4 different decisions. It was 5-4, though, at least as to the ultimate result. The lead opinion was by Chief Justice Roberts. He vacated the Federal Circuit's decision holding that the APJs were unconstitutionally appointed by the Secretary and said Arthrex is not entitled to a hearing before a new panel of APJs, which is what the Federal Circuit panel had said, which is we're going to fix it by sending it back in part, at least in this case, to a new panel. They vacated the Federal Circuit's remedy of severing the Title V removal protections for APJs, which, again, in my view, is a very good thing, and said that APJs can function as inferior officers so long as the director may review final PTAB decisions, and upon review can issue decisions himself on behalf of the board. The court did say that Section 6C of Title 35 is unenforceable as applied to the director insofar as it prevents the director from reviewing decisions of the PTAB on its own. So that last sentence of Section 6C had said that the PTAB is the one who hears requests for rehearing. And here the court said instead the director may unilaterally engage in the review and reach his own decision. So the opinion did leave open, however, what might happen with respect to other adjudications. So this was a decision relating to a review of inter-parties review proceedings. The court said we do not address the director's supervision over other types of adjudications conducted by the PTAB, such as the examination process for which the director has claimed unilateral authority to issue a patent. So what might happen with ex parte appeals, appeals from reexamination proceedings, we'll have to see there. As a caveat, I'll say that the Federal Circuit had said, in some of their other opinions, there was one in Re Bolero Global in Vernetics case. They basically said, well, if the APJs are unconstitutional for one purpose, they're unconstitutionally appointed for one purpose, so they would be unconstitutionally appointed for all purposes. So the Federal Circuit rationale is it would apply that they should be treated the same for any purpose. So we'll see if that holds or not. And the decision provided the director with broad discretion. So the court said, to be clear, the director need not review every decision of the PTAB. What matters is that the director has the discretion to review decisions rendered by APJs. In this way, the president remains responsible for the exercise of executive power, and through him, the exercise of executive power remains accountable to the people. So now, once the Supreme Court decided Arthrex, case is remanded, and next I'll turn things back to Scott, and I think we'll next talk about what happened with the PTO, with the U.S. PTO.
Sure. And just so for the non-lawyers in attendance, at a high level, what the Supreme Court is saying, which is a lot of what was said here earlier, which is, well, wait a minute, the PTAB has too much power here. You have judges that they weren't confirmed by a Senate, right? They weren't appointed to a life term, and yet they're making decisions to invalidate patents that go directly to an Article III court, and there's nothing in the middle. So no agency really, operates this way because that's what the Appointments Clause is there to guarantee. For those appointees, they make those kinds of calls. They make the policy calls, and that's the way all these agencies work, and yet the PTO wasn't doing that. So just before I get into quickly the nuts and bolts of the rehearing option that's available, Gene, let me ask you, ultimately what the petitioner at the Supreme Court was looking for, was swinging for the fence, which is, well, if that's unconstitutional, the whole house of cards has to collapse, and yet the Supreme Court just sort of lasered out a few words, and what's your take on that?
So as you know, Well, many of you in the audience don't know this. Scott knows this. I'm probably hated by everybody. I mean, sometimes I don't think I have any allies, because the people who are pro PTAB obviously don't like me, you know. But the people who are anti PTAB, they don't like me either when they hear me say that, you know, the PTAB is here and it's here to stay. It's not going anywhere. For a whole variety of reasons. One, it can't go anywhere. It's in the statute, and it's not politically non-feasible to have it removed. Two, even if we could get it removed, it's still going to be there because they have to have somewhere to address ex parte cases, right? I mean, you know, so I think it's absolute folly to start with we need to abolish the PTAB. Okay, so that then makes me hated more so by the anti-PTAB forces, because you should get it, Gene. You're on our side, right? So it's like I'm a turncoat, you know? So I think it has always been a mistake to try and go for the, you know, the silver bullet, you know, killing the werewolf analogy with the PTAB, because it's never going to go away. You know, even if the PTAB were the worst conceived institution in the history of man, does anybody think Congress 10 years in would admit that they made a mistake? I mean, you'd be asking many of the same people who voted yes to now vote no. It's not going to happen. So that was always a mistake.
And don't forget, it's the Leahy-Smith America Invents Act.
Right.
And Senator Leahy is the chair of the Senate.
Yeah, and
Judiciary
he's still around. He still has even if he wasn't, he's still in the Senate. He still has a vote. People are not going to vote against his signature, one of his signature bills, you know? So that was always a mistake. What we needed to do was, and I've written this, is we missed our opportunity. The opportunity was, and this, I can guarantee you this was on the table. I don't know whether it would have happened, but this was on the table and being discussed behind closed doors in DC, is to take the reforms that Director Iancu had gotten through to PTAB and to put them into legislation. So at least we had that, and it couldn't be overturned by the next person to sit in that chair. And that was unacceptable to the people who were in the pro-invention community, because it didn't go far enough. So we're at a place politically where you can't accept half a loaf of bread, because it's not a whole loaf of bread. So the Ronald Reagan, Tip O'Neill way of legislating, which worked, you get what you want, I get what I need, and then next time you get what you want and I get what I need, you know, vice versa. That doesn't exist in DC anymore.
Well, and it's a little off topic, but we saw that play out in 101, where you just had the two sides. You know, you had an investment in hearings where there was something like 40 plus witnesses in a couple days, and then there was all of this momentum, and then it just fell apart.
And it's the same cast of characters on all sides that say no. If I either get the entirety of what I'm asking for, or I'm going to take my baseball and go home, just like they're 8 and 9 years old, you know, and it's totally unfortunate, you know. It's just not gonna happen. So I would have thought that the way to address this would have been to try and get the reforms that we wanted. The Iancu reforms would have, I think, been easy to legislate. I think. The next step of the reforms, which many of us wanted, was, you know, an equality of not preponderance, but clear and convincing. You know, those changes to make it more equivalent to district court, those were being discussed, but would have been much, much, much heavier lift. And probably, if I had to guess, if I had to bet money on it, I would have bet no, those would not have happened. But you know, the way that patent legislation works is you have to have those serious discussions with people who are on the other side, who disagree with you. Because what you discuss today may happen 5 or 6 years down the road. You know, but when you say no, absolutely not, because I'm not going to get what I want, 100% of what I want today, you're never going to get to 5 or 6 years down the road. So we should have taken what we wanted, what was the low-hanging fruit, had the conversation about what the goals were to plant the flag for the future. And that's the way business is done in DC. And that just did not happen.
And I think Arthrex in some ways aggravated the situation because it put the emphasis on, well, hey, there's a political appointee that comes in that can drive policy. And so now you have, individual political parties jockeying for pro-patent or what's, considered anti-patent to get their person in there, which is in part probably why we don't have a director right now.
That's exactly right. And I mean, for those of you who aren't in the DC area, I mean, Scott's exactly right. I mean, that's why we don't have a director. I mean, a couple people have gotten close to getting ready to be vetted or were in the vetting process, and constituency groups vetoed them.
Well, let me quickly just go through what the fix was, and then Sharon, I'll come back to you on what the next flavor of constitutional challenge might be. But I always looked at the Arthrex dispute as very interesting from an administrative law perspective because it had the potential to impact a lot of different areas of the administrative state. But ultimately, as a practitioner, I just kind of shrugged it off and said, well, worst comes to worst, they're just going to have the director have the last say, sort of akin to the ITC, where you got to get past the commission.
But that's where the next case is going to come from.
Probably correct. So where we ended up was, okay, well, if the political appointee has to have the last say, then let's add a new rehearing option where you can just ask the director to step in. And I think there was this initial enthusiasm of, great, finally I can talk to someone who's sane and who will, give me my patent back. And there's been a number of filings, some of them were in my cases, and within 2 or 3 weeks you got essentially what you would see from the Federal Circuit, like a Rule 36 saying, I incorporate the panel's reasoning as my own. So I think for patent owners, it really fizzled as an opportunity, or at least what was perceived as an opportunity, because the director, while a political beast in a lot of respects, at that point, that record's going to the Federal Circuit, and you just can't jump in and say, well, I like patent owners, here's your patent back. So, like I said, as a practitioner, it's somewhat of a non-event. It's an option. You can certainly ask for it, but it's a lot like the precedential opinion panel, where it's 1 in 100 cases that's probably going to get the attention that you want. And then if you do reverse it, then the other side can ask for another panel rehearing. So it's, from a patent owner perspective, I don't think at the end of the day it really accomplished anything.
Right. No, I would agree with that, but I would like to go back to where you said the director is a political operator. Drew Hirschfeld's and he's not even the director. I mean, and that irritates me because now his title is performing the functions and duties of the Undersecretary of Commerce for Intellectual Property and Director. It's like the longest title ever in the history of politics. And I believe the reason why he has the performing the duties of, there's a statute that says you can't be acting, there's 2 statutes in question. The most direct one is you can't be acting director if you are not the direct report to the director. And Drew was not, because there was a deputy director, and then Drew was the 3rd person in line. He was a commissioner. So Drew does not qualify to be acting director. And then there's another statute that says you can't be acting for more than 9 months. So they started, people who otherwise might have been able to be acting, I think this happened during the Trump administration and late in the Obama administration, they started saying performing the duties of, because they didn't know whether they would have a replacement within 9 months. But Drew is not a politico. Yeah. And the rationale, I think undeniably, as Sharon, you were reading, the last quote you read from the Supreme Court is that the appointee of the president is going to make sure that the will of the people is enforced or considered. Well, I like Drew. I've been friends with Drew for years, back when, well before he was in these positions he's held of power at the Patent Office. So I'm thrilled that he's running the Patent Office. I can tell you without no doubt the Patent Office is in very good hands with Drew. He's a great, solid citizen, good guy. But he is not appointed by the president. So I see if he's making these decisions on these rehearings, that it falls for constitutional infirmity for this same reason, because at least based on the rationale of the Supreme Court.
That was my initial reaction. I'm going to come to you, Sharon, I promise. But at the same time, he's issuing patents as well, right? So there are things that he is doing as an interim.
It could go either way, right?
And there is that period where it's like, well, agencies have to operate while they're looking for a new head, so it
That's right.
seems like there's a limited time where it can work, but we're probably getting to the back end.
We're getting close to that, because there are also statutes that say that when you are either acting or performing the duties of acting, you have all of the authority that is vested in the director. And those are the statutes and lines of cases that the Patent Office is relying on. The only authority I'm relying on for what I said is the decision in Arthrex, which seems completely based on the presidential authority, and that's why we said that these judges don't have the authority to do what they're doing. So the analysis could go either way.
And that gets us to where we're headed, which Sharon's going to tell us all about the next major constitutional challenge, right?
No pressure.
Yeah, no pressure at all. Well, one of the next major, I don't know if this is major. I think this is going to be a blip. I think there are some challenges as to whether Drew Hirschfeld can be performing the functions that he is, and when thinking about it for me, well, that would mean that we would probably not be able to have, a lot of the executive agencies wouldn't be able to perform their functions at all when you have a change in administration and you have somebody who's in some sort of performing the functions and duties roles for some period of time. The Supreme Court in its decision actually said, I mean, it recognized that we have we have somebody in the position who's acting right now, and it said that the case here should be remanded back and could be reheard by him. Mm-hmm. So I think that they contemplated that, and I don't see a challenge specifically there going for very long. But talking about, are there other constitutional challenges to be had that we might see down the road? And yes, I think that we've seen a number of challenges. The first constitutional challenge we saw was in Quozo, and some of the challenges, and then we saw the challenge in oil states, which really went to this whole statutory scheme, and this was another way. The Appointments Clause challenge, I think, was another way of attacking the statutory scheme, and it seems that the Supreme Court seems to be content that, the structure is in place, is what Congress intended, and they're going to uphold that. I think that there's still room for some due process type of challenges. We do see those percolating, and I think that those are still, I'm not going to say, I don't know how much legs they're going to have, but I do think that those could still have some teeth, and we'll see some of those challenges that'll be made. But in terms of, we know that institution decisions, so the decisions at the front end aren't going to be reviewable. We've seen limited. There's certainly a lot of limits on I think we've seen the Supreme Court address just about every angle, but they have left a few issues open.
They've certainly, I think they've had 4 or 5, maybe a little higher than that in terms of just PTAB cases that have come up.
I think this is the 6th.
Yeah,
I was counting, which
exactly.
is incredible, because the PTABs, the AIA trial proceeding system started in September of 2013.
Right.
So that's when the first trial proceeding was filed, which meant you're looking at another 18 months or so before there's an actual decision, although I guess there were some quicker decisions. But the first decision we saw from the Federal Circuit came out in, I think, 2014. Mm-hmm. And then, since that time, so we're talking in the last 7 years, we've had almost one case a year that the Supreme Court has taken that's just reviewing basically appeals from the PTAB.
And I think it was Justice Gorsuch in his dissent on Arthrex that was sort of indicating at least he expects some some due process challenges to come. We'll see if that happens.
You know, I'm going to throw out one other too, because I think we're going to see something that has to do with Chevron deference.
I think the conservative justices would very much like that.
Yeah.
Well, you know, there was some people who thought that that was the way that they were going to approach oil states, because there was, and I believe it was Solicitor Varelli, after he left the Obama administration, was predicting that may be a way, because
I thought the SAS case was more.
it may be maybe I'm thinking about the SAS case, but because there may be a lot of things that conservatives and Republicans may want to say about the EPA that they could never really say, or at least telegraph in an environmental case, without, you know, having literally hundreds or thousands of amicus briefs and really riling up everybody. But if they say it in a patent case, it's a sleepy patent. It would have applicability across the board to agencies.
Right.
So I think that that is a really good prediction, is the Chevron.
One interesting argument, and I've seen this on your blog, Gene, and it wasn't fully heard at the Federal Circuit for other reasons, but this concept that the agency has a sort of a built-in bias because of the way that these proceedings are paid for and how they may be financing the office. And so just wondering if you could talk a little bit about your thoughts on that.
Yeah, you know, and when you do the math, and the PTO, okay, so I know I see two former directors in the room, so, you know, and they're both friends of mine. So, but so far, thanks, Ted. But when you do the math and how they lay these things out in the Federal Register notice, they don't actually make it clear that the money that comes in from PTAB fees is insufficient to cover the budget for the PTAB. Okay, so that means that the money for the PTAB has to come from somewhere else. Now, I don't think it's a ton of money. I don't think we're talking about you know, like a huge amount of money. But you know, from, you know, in a Pollyannish way, in an idealistic way, I just think that that's offensive. I think that if you are going to try and invalidate patents after the fact in a form that we all know is far more friendly to the challenger, that the challenger ought to have to pay enough to run that challenge. And you ought not to be asking patent owners through maintenance fees. And that's really what it is, because it's not really the people on the front end, because the people on the front end don't pay enough for the work the examiners do anyway. It's the people who own the patents. So in this ironic way, the people who own the patents are subsidizing the PTAB. And to me, that just strikes me as bizarre. And it's in the delta. It's not huge, but there is a missing delta. So that just does bother me a lot. And you know, and if you look at what bothers me about the PTAB, it's a lot of these things around the edges. You know, it's because I'm not the blow up the PTAB kind of person. You know, in an ideal world, I wouldn't have had these IPRs, PGRs, or CBMs. And I would change it. I would legislate the Yonko reforms, and I would change it to clear and convincing. And I think that when Director Kapos was in, Director Kapos predicted about 500 of these IPRs a year. I think that's probably the right number, because if you look, we had about 500 inter-parties re-exams. You know, this was supposed to be about the worst of the worst patents, you know, the ones that slipped through. Or later on, you know, you discover that there was, you know, a PhD thesis that nobody really knew about, or some other thing, you know, and you fix those things. But when you're having 3.5 to 4x those numbers of cases, and in some cases, I know FinJan was fighting off, they had 120. At one point, they were like 100 and 0. They won 100 cases, and they only had a 28 patent portfolio, you know? I mean, that's problematic, I think. So those are the things that bother me. So from an institutional perspective, I would worry about fixing those levers. You know, like the engineer in me sees a system that has a bunch of levers that just obviously need to be flipped in a different direction.
One of the things you mentioned a few times were the proposals to codify some of the 314A practices, and I'll just throw it out to both of you. Do you think that this discretion that's being applied on a case-by-case basis, that's, again, going back to these judges that, on the one hand, people are arguing have too much power, but yet when they're sort of, deciding what's best for the patent system on an individual patent basis, and it's to the benefit of patent owners, there's not so much of the complaining. So what's your thoughts on 314A? And I should mention there's some litigation ongoing. Maybe there's an injunction, but let's assume that it sticks around. Should that be something that these judges should be doing, deciding, for example, just to use the DivX, I think it was the DivX Intel verdict, which was $1 billion or $2 billion. You had an individual judge at the PTAB deciding that it's best for the patent system that this dispute be heard in the district court. And I don't work for any of these folks, but let's just assume that the PTAB would have been successful in defeating some of these claims. And we all beat up on these big companies as well. They hate patents, but that's a lot of money. That's a lot of engineers that could be laid off. It's a lot of research that's not happening. What's your thoughts on whether or not that kind of discretion belongs with the PTAB?
Do you want to go first or do you want me to? I'm happy to go first.
Go ahead.
Okay.
Go ahead.
I don't like that the judges have that much power. I think the judges have too much power. But I think somebody needs to have that power. And if I were setting this system up, I would not have delegated the ability to the judges on the panel to decide whether to take the case, because those are also the judges that are going to hear the case. And those are, so I don't think that that's the right way to do it. I think, the director, I think, needs to have more control over this. And I think that this is what the Supreme Court was saying. And I have long thought that obviously you can't have the director reading through these things. But, the Patent Office historically, for these types of sensitive issues and important studies and important programs, there's a SWAT team of really high-level people in the Patent Office. Those of you who know what I'm talking about, the names of some of the people. I mean, like, for example, Rob Clark at the Patent Office. Rob Clark would get assigned to do this, and then he'd get assigned to do this, and then he'd get assigned to do this, because he's competent. And you need something done, you put Rob Clark in charge. And he's not the only one, but there's people like that, right? He was a judge for a while, he was chief of staff for a while, he was in charge of Office of Legal Administration for a while. Those are the types of people, I think, you could put together a team and have the director's authority delegated to that team and have it much closer to the director for decisions about institution. And then I think you would have that ability to have that proper exercise of policy. But I don't think in the PTAB, because you hired these judges because they were scientifically expert, particularly the ones you first hired. There were so many PhDs, right? That I don't know that those are the people that you want to be vesting the policy decision making in, because you hired them for their scientific competence.
Sure.
Okay. So first, my caveat, these views are mine. They shouldn't be attributed to my firm or its clients. I look at it, I guess, a little bit from a practical standpoint too. I mean, I think for the PTAB to be able to function and issue decisions in a timely fashion, it's got to have some there's got to be discretion involved. I do think it's helpful to have some, factors and more precedent, I guess, precedent or policy, or I personally would rather see more of go through notice and comment rulemaking than a bunch of precedential decisions, that get a little more vetting, that are subject to a little more public input, and to the extent we're not going to have statutory factors. I mean, if we can go to get something legislated, great. I think that's difficult, but I think that while there are decisions that I disagree with, and there's certainly I would rather see cases that I would rather see the board not institute than go ahead and institute something that was really borderline, and then you go through 18 months later and then get a final written decision where the board seems to basically flip 180 degrees from where they started. And there may be reasons, there may be good reasons for that. It may be that the patent owner really did a really great job and it wasn't as good of a petition as they thought at the outset, but it certainly would be more efficient to have something denied at the outset. In terms of just saying you get your right to go and have a trial proceeding as opposed to going to district court, I don't know that that's always true. There's some cases that, if it makes sense, sure, but I do think the board needs to have some level of discretion, but there needs to be good guidelines for it to exercise and operate in its discretion. My preference would be, like I said, to go through and have notice and comment rulemaking where you've got good guidelines for how it would exercise that discretion. I think one of the issues that is going to be out there is the fact that institution decisions aren't appealable. That does seem unfair. And maybe there's still an opening where there could be some mandamus, the right case where you've got a writ of mandamus that you can try to get from an institution decision.
I think the frustrating thing, I think, being a practitioner is this is matters of discretion. So there's no precedent on one person's discretion relative to another. So you can have the exact same facts and it becomes very panel dependent. And then because you have this creature, this discretionary creature, and we had Judge Albright here earlier, who is now looked at as well, in tandem with 314A, that's kind of the antidote to the PTAB, or you can go to the ITC and they won't stop. So you almost have this de facto policy being made by this, this combination of just, agencies and courts. And I know that talking to some of the congressional staffers back in DC that, they're looking at, fixing some of the, well, I shouldn't say fix, but modifying.
But they should. I mean, they should, right? I mean, that was what I thought when we were going through the AIA in the first place, where we were going to do. I thought we were going to streamline this stuff.
Yeah.
I mean, you couldn't, junk on a bet, come up with a dumber system. I mean, we have an ITC, and we have the federal courts, and then we have a PTAB. They all go at different speeds. They're all appealable to the federal circuit, and there's different standards of review. So now the federal circuit has got multiple cases where they say, oh, your patent's good from this coming up this way, and your patent's bad. Same patent, same claims, bad coming up that way.
And I mean, there's an international flavor to it.
And there's international flavor.
You're in Dusseldorf trying to get it, an injunction.
Right. I mean, I thought we were going to streamline this, and I was all in favor of streamlining it, and then I saw what we were going to do, and I'm like, who came up with this? And then we had, I didn't say this, but I'm going to say it anyway. I mean, then we had, for like several years, we had to sit through CLE, listening to people who helped put this together saying, oh, this is so beautiful, it's so wonderful, and I was sitting on these panels, and I would get my turn to speak, I'm like, I want to carve my eyes out with a dull spoon after I read this, are you reading, are we talking about the same law, So I'm all in favor of going back, because this is not good for anybody. I mean, not true. It's good for all of us in the room. It's not good for anybody who's a client, right? And that's why people always, they complain to me. You maybe see this online. Whenever I write something, they say, you're just complaining because this is going to take away work for lawyers. I'm like, oh, you are so naive. Every time Congress acts, every time the Supreme Court says anything, that's more money in our pocket.
But I do think that to your point, Gene, there is a feeling that some things are unwinding in a way that they shouldn't. We see people going back to the reexamination system because they're getting rejected on discretion. And as I said, there's this whole interplay with what court to go to, and in some cases, foreign courts. Well,
let me ask you, both of you guys, this question, because the one thing that came up, because I suspect we're probably running close to 5 minutes. I suspect so the thing that's come up over the last week or 10 days that I think has a chance to unravel the PTAB, not directly, completely indirectly, is the ruling from the Ninth Circuit and the ruling from the Federal Circuit. In the Ninth Circuit, the ruling was relating to a license where there was a forms selection clause, And it said disputes regarding the patent have to be handled in the Central District of California. And there was no carve-outs for allowing the PTAB to handle any invalidity disputes relating to the patents that were in that in that license. So that the patent owner filed an injunction, and when the proceedings was started at the PTAB, and it went all the way up to the Ninth Circuit, and the Ninth Circuit said, well, there's form selection clause is pretty clear. This is all to be decided in the Central District of California. No carve out for the PTAB. The PTAB cases have to be enjoined. You guys need to dismiss your PTAB case, okay? Then there was not the identical case, but certainly the identical issue in the Federal Circuit dealing with an arbitration clause. So the license required that there be arbitration of all the issues. So in that scenario, what the Federal Circuit said was pretty much the exact opposite of what the Ninth Circuit said. And even though you can arbitrate any issue relating to the patent under IPR, the Federal Circuit, for reasons that I can't understand and reasons Judge O'Malley didn't understand, she dissented very strongly, they decided that the arbitration clause did not prevent the PTAB from exercising jurisdiction. So although they're not exactly on point, those decisions, they're clearly in the same area. So now you're going to have litigators and patent owners looking at licenses and see are there arbitration clauses, are there forum selection clauses, and that may defang the PTAB in some areas, at least until the Supreme Court gets involved, I think. Thoughts, you two? Am I making a mountain out of a molehill?
Well, I think, to your point earlier, though, do we want people that were hired for technical expertise now becoming contract specialists, right? The earlier panel made the point about we have litigation about what, and you know, sometimes these form selections are pretty straightforward, but maybe that is the best way. Go back to the Article 3 court, get an injunction, right? I mean that probably makes the most sense, you know, from my perspective. I don't want the PTAB construing my contract any more than I want them deciding what's best policy for me. And Sharon, I don't know what your thoughts are.
Yeah, well, first, I think there's a lot of work there for those who are working on agreements. You might want to consider what you put in a form selection clause in some agreements, because this seems like an issue that actually the Supreme Court would, I mean, if they could get their hands on, might like. It's way more interesting to them than 101 issues. So
yeah, this has got the Supreme Court written all over it because it's patents, which they seem to be interested in, but it's not patent case. You know, it's a contract case.
But to the earlier panel's point, you're not having those conversations, right? You know, the minute you start sending NDAs to people, you're going to see your petition come in, and you know, maybe for a recurring, you know, royalty or license agreement between big companies, I'm sure they're going to put those you know, arbitration or choice of forum. But if you're a small inventor, you know,
And the clause is what the clause is, you know,
Yeah.
but you got to take it or leave it.
Right.
Yeah, but for those, I mean, there's a lot of people here to do big deals. The moral of that story is those arbitration clauses and the form selection clauses, they're not form clauses anymore. I mean, at least moving forward until the Supreme Court finally decides, they're strategic clauses at the moment. And you need to go back and look through your licenses and agreements to see if you have any things to, because litigation is all about creating leverage, right? You know, you don't have to win. I mean, because how often do you win in litigation? You know, well, of course you win 100% of the time because the settlement was always in your favor, right? That's what you tell the client at least. But you're going to settle these cases. So what you're doing is you're just trying to create leverage. And that gives you, I think, a great way that you might be able to create leverage where there has been no leverage to create for a whole lot of patent owners for a very long time.
Right. I'll just close it out to say to patent owners, there is an appetite in DC to make some changes to the legislation, and I think that's your best foot forward. At least my view, and I represent patent owners all the time as well. There needs to be less sort of teeth gnashing about the judges are frauds or fakes, and I think you want to channel your energy into explaining your side of the story. There are ears there that are willing to listen, and you know, I would just encourage you to channel it to your representative, and you know, go to those meetings, go to those hearings. I know a lot of you do, But, you know, to make the system better, that's what it's going to have to be at this point. I don't expect any constitutional challenge to pull down the system at this point.
No, I would agree with that. Would you agree with that, too?
Oh, yeah, I agree. I agree. Although I'm gonna differ a little bit from Scott, because I think, yeah, I mean, there may be opportunities for legislation, but I just think in this Congress, you're not going to see any movement for
Slight tweaks.
Yeah, for some time, maybe slight tweaks. I think if Arthrex had come out a different way, we might have seen something, but I think that the way the decision came out, it was tailored narrowly enough. We're probably not going to see any movement there.
Well, I think that's a good place to wrap it up, and I'll just plug the panel tomorrow at 11:15 is specific patent owner strategies at the PTAB, which will be in the Knowles room. So if you're interested in that topic, happy to talk about that tomorrow. And thank Gene once again for having the panel and providing me a security escort.
Great. Well, thank you very much, Sharon. Thank you very much, Scott. And I'll also say Scott has just signed on to be co-chair of our PTAB program in January, so we'll be doing that virtually, so hopefully you'll be hearing more about that as well. So we'll take a panel picture, and then we'll move on to the last segment before the reception.